New York real estate broker exam prep. Let's get started. A commercial property in Queens generates $100,000 NOI. Similar properties sell at an 8% cap rate. What is the value? Is it A, $1,250,000? Or B, $800,000? Could it be C, $1 million? Or lastly D, $12,500? The correct answer is A. Here is why. Value equals NOI divided by cap rate. $100,000 divided by 0.08 equals $1,250,000. Option A is correct. Option B, $800,000, would be 12.5% cap rate. Option C, $1 million, would be 10% cap rate. Option D, $12,500, incorrectly divides cap rate into NOI. Next question. A real estate salesperson in Staten Island advertises a rental property online with the phrase "ideal for young singles, no families please." A family with children inquires, and the salesperson discourages them from applying. Under New York State human rights law and federal fair housing regulations, what violation has occurred? Is it A, no violation, as landlords can set tenant preferences for rentals? Or B, discrimination based on familial status, which is a protected class? Could it be C, only a violation if the property is federally subsidized? Or lastly D, steering is the only prohibited practice here, not advertising language? The correct answer is B. Here is why. Familial status is a protected class under the Fair Housing Act and New York human rights law. Advertising that states or implies preference against families with children is discriminatory. Option B is correct. Option A is incorrect. Tenant preferences cannot discriminate against protected classes. Option C is incorrect. Discrimination is unlawful regardless of subsidy. Option D is incorrect. Discriminatory advertising is itself a violation. Next question. In Syracuse, the assessor determines property values for taxation. What agency oversees this? Is it A, municipal tax assessor? Or B, Department of State? Could it be C, planning board? Or lastly D, zoning board? The correct answer is A. Here is why. Property assessment is performed by the municipal or county assessor. The assessor determines market value for property tax purposes. Option A is correct. Option B is incorrect. Department of State licenses professionals. Option C is incorrect. Planning boards review land use. Option D is incorrect. Zoning boards hear appeals. Next question. In a dispute over a shared driveway in Buffalo, two adjacent property owners argue about maintenance responsibilities. The driveway was established by a written agreement 20 years ago, but was never recorded. Is this easement valid under New York law? Is it A, yes, as long as it's in writing? Or B, no, because it wasn't recorded? Could it be C, yes, if it's an easement by prescription? Or lastly D, no, unless both parties agree now? The correct answer is A. Here is why. An easement created by a written agreement is valid between the parties regardless of recording. Recording provides constructive notice to subsequent purchasers, but is not required for creation. Option A is correct. Option B is incorrect. Recording is not a condition precedent to validity. Option C is incorrect. The easement exists by express grant, not prescription. Option D is incorrect. The existing written agreement is binding. Next question. In Rochester, a property owner refinances their mortgage through a FHA loan, which requires mortgage insurance premiums. The owner asks their real estate salesperson if this insurance can be canceled once equity reaches a certain level. What is the correct response under New York finance rules? Is it A, yes, after 20% equity? Or B, no, FHA MIP is permanent? Could it be C, yes, immediately upon request? Or lastly, D, no, only for conventional loans? The correct answer is B. Here is why. For FHA loans originated after June 3, 2013, with less than 10% down payment, MIP is required for the life of the loan. Option B is correct for this common scenario. Option A is incorrect. This applies to conventional PMI, not FHA MIP post 2013 with under 10% down. Option C is incorrect. Option D is misleading. FHA MIP may be removable under specific conditions, 10% plus down 11 years, but the question implies the permanent scenario. Next question. In Albany, a purchase contract for a home states that the closing must occur on or about June 1st, but the seller delays until June 15th due to personal issues. Is the buyer entitled to cancel under New York contract law? Is it A, yes, if time is of the essence? Or B, no, on or about allows flexibility? Could it be C, yes, always for delays over 7 days? Or lastly, D, no, unless specified in writing? The correct answer is A. Here is why. In New York real estate contracts, time is of the essence must be expressly stated to make deadlines strictly enforceable. Without such language, on or about permits reasonable flexibility. However, once a party demands closing and makes time of the essence, the buyer may cancel if the seller fails to perform. Option A is correct. If time is of the essence, the delay may justify cancellation. Option B is correct generally, but does not address the buyer's right to declare time of the essence. The better answer is A because the question asks if the buyer is entitled to cancel, which requires time to be of the essence. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.